Geico versus Mayzenberg was a civil RICO case that was filed in the Eastern District of New York almost 8 years ago. And the case was litigated tooth and nail, in excess of 30 depositions. We had summary judgment motions, cross-summary judgment motions, and ultimately we had a ruling from the Eastern District in 2019 where the court ruled against us in favor of Geico on their civil RICO and fraud claims. We appealed that decision to the Second Circuit Court of Appeals. The appeal was based on the argument that the eligibility issue that Geico had claimed, specifically that the payment of kickbacks would render our client ineligible for reimbursement in no fault, was simply not true and not consistent with New York law. Our client was an acupuncturist who owned multiple acupuncture professional corporations. Geico alleged that he had paid money in order to induce patients to treat with his companies. The court ultimately found that he did in fact pay kickbacks for that purpose, which we disagreed with at the time. We still disagree with it, but the court believed that that's what happened. They found that because he did that, that rendered him ineligible under the no-fault regulations. Those regulations essentially say that you have to be in compliance with local and state licensing laws in order to be eligible for reimbursement under that program. We interpreted that regulation to mean that a licensing law has to be a structural licensing requirement. And there were two seminal cases essentially from the New York Court of Appeals, the highest court in the state of New York, that supported that. The federal court said, we disagree. We think that this constitutes bad behavior, and we think that this is a licensing issue because Dr. Mayzenberg could lose his license, and therefore he's ineligible for reimbursement. We took that decision. We went to the Second Circuit Court of Appeals. I argued the case before the panel, and the panel was very receptive to my arguments. And they seemed to agree with me, but struggled with the idea that this was something new, and that perhaps this was something that New York state courts should be making a decision on and not the federal judiciary. Not surprisingly, in their decision, the Second Circuit Court of Appeals said, we believe this is a novel issue that should be resolved by the New York Court of Appeals in Albany, which is the highest court in the state of New York. The Mayzenberg appeal was argued before the Court of Appeals in October of 2025, and a decision came down in December of 25, completely agreeing with us. They ruled for the first time that as a matter of law, the payment of a kickback did not constitute a licensing violation sufficient to deem the medical provider ineligible for reimbursement under no fault. An enormous case for us, an enormous shift in the industry, and it affects hundreds and hundreds of cases filed by insurance companies claiming violations of disciplinary rules were sufficient to render someone ineligible. And I believe that what ultimately persuaded the court to rule the way they did was that the insurance companies have just pushed too hard and have taken too much liberty enforcing rules through civil RICO cases, particularly in the Eastern District. Since 2025, the number of cases that have been filed have increased exponentially, and I think that the insurance department and ultimately the Court of Appeals have looked at this and said that we think that the tools that we give to the insurance companies are specific tools. And what they've been doing with the federal civil RICO cases is taking it a little bit too far. And I believe that this decision represents the states speaking to the insurance companies saying, we're gonna pull back a little bit on what we're giving you as tools to verify claims. And we think that it's up to the state to enforce disciplinary rules. It's not up to the insurance company who's getting bills to say, we unilaterally believe and decide that you're ineligible. That's something that the state should be deciding on their own. So we think this is a tremendous victory for medical providers, and we think that it's shifting the balance of power back into a position that it should have been from the beginning. And ultimately, that's what the case represents. The state saying to insurance companies, we are going to dampen the powers that you have to investigate claims, to deny payment, and ultimately to bring civil RICO cases to try to claw that money back.